All right, Madam Clerk, you can call the case.
State of Wisconsin versus Darnell Howard, 21 CF 2232. Appearances, please.
Dan Flaherty for the state.
Darnell Howard appears in custody via Zoom with attorney Amanda Kramer. Good morning.
Okay, good morning. This case is set for a plea hearing. We just put it on the calendar yesterday. The case is set for jury trial in April 11th, I believe. But the court was notified that the parties have reached an agreed resolution, and so we put on the calendar for a plea hearing. So, Ms. Kramer, you and your client are ready to enter a change of plea, guilty plea today?
Yes, Judge.
All right, Mr. Flaherty, why don't you start us out by stating the terms of the offer in regard to this proposed plea?
Yes, Judge, of course. If Mr. Howard is to enter a guilty plea to count 1, which is the first-degree reckless injury with a dangerous weapon, the state would dismiss but read in count 2, felon in possession of a firearm, and make a recommended sentence of 6 in and 3 out, concurrent to his current revocation.
Okay, and Ms. Kramer, the terms of the offer that Mr. Flaherty just stated on the record, that's your understanding of the offer?
That's correct.
And Mr. Howard, same question to you. The terms of the offer that the state's attorney just stated on the record, that's also your understanding of the state's offer?
Yes, sir.
Okay. Mr. Howard, just one thing I need to confirm with you. We're obviously conducting this hearing over Zoom. Do you understand that you have a right to have an in-person hearing for this type of hearing if you wanted to? Do you understand you have that legal right?
Yes, sir.
All right. And you are agreeing to hold this hearing via Zoom, is that right?
Yes, sir.
And so by agreeing to hold the hearing via Zoom, you understand you're giving up your legal right to have an in-person hearing in my courtroom. You understand that?
Yes, sir.
Okay, great. All right. Mr. Howard, I have to say the following to everyone who enters a guilty plea, whether it applies in particular to you or not. So if you are not a citizen of the United States of America, you are advised that a plea of guilty or no contest to the crime you're charged with could result in deportation, exclusion from admission to this country, or the denial of naturalization under federal law. And if you are a U.S. citizen, then what I just said does not apply to you. Okay. In this case, Mr. Howard, you understand you were charged with 2 crimes, count 1 being first-degree reckless injury with use of a dangerous weapon, and the second count is felon in possession of firearm. You understand those are the 2 charges in the case?
Yes, sir.
And under the plea agreement, you'd be pleading guilty to the first charge, and the second charge would be dismissed but read in. You understand that?
Yes, sir.
And did your attorney explain to you what the concept of dismissed but read in means?
Yes, sir.
All right, very good. And so, Mr. Howard, I saw from the plea questionnaire form that you obtained an HSED several years ago, is that right?
Yes, sir.
And so I take it by the fact that you were able to get your HSED, I take it that you could read through the criminal complaint that the state filed in this case. You could read through that document yourself?
Yes, sir.
And did you do so? Did you read the criminal complaint yourself?
Yes, sir.
Okay. Did you also go through the criminal complaint with your attorney at some point in time where she talked to you about the charges in the case and the facts in the criminal complaint that would support the charges?
Yes, sir.
All right. So by reading that criminal complaint yourself and by going through it with your attorney, did you come to understand the charges against you and the facts that the state was relying on to take the charges against you?
Yes, sir.
Okay. Very good. Let me ask you then, I'm just pulling up your case file on my computer. Is it true, as stated in count 1 of the information and the criminal complaint, that on or about May 28th, 2021, at the address of 2352 North 17th Street in the city of Milwaukee, you did recklessly cause great bodily harm to a person with the initials MRH, who is another human being under circumstances which showed utter disregard for human life. Is that true as stated in count one?
Yes, sir.
Okay, thank you. Ms. Kremers, let me ask you, can I accept the facts contained in the criminal complaint as being true and accurate as they relate to the plea to count one?
Yes.
All right, thank you, I will. So, Mr. Howard, I'm going to accept the facts in the criminal complaint as being true. Do you understand that and agree that I may do that?
Yes, sir.
Okay, very good, thank you. So what the criminal complaint states is that you were driving around with two other people in a car, and at some point you got out of the car. They came back to, I guess, drop off a phone or something, and you had an argument with the driver of the car, who was the person with the initials MRH. And in the midst of that argument, while you were standing out the passenger or standing next to the passenger window, you shot into the car at MRH, and the bullet hit him somewhere in the leg or back. Is that true as stated in the complaint?
Yes, sir.
Okay. Your attorney has filed a number of documents with the court in anticipation of this plea hearing. One of the documents that your attorney filed is the jury instruction for the crime of first-degree recklessly endangering safety. And that jury instruction lists the factual elements of the offense. Those are the elements that the state would have to prove beyond a reasonable doubt for a person to be found guilty of that type of charge. Did you go through the criminal complaint with your attorney? I'm sorry, did you go through the elements of the offense in that jury instruction with your attorney?
Yes, sir.
And so by going through that, you came to understand the facts that the state would have to prove beyond a reasonable doubt for you to be found guilty of the crime of first-degree reckless injury with use of a dangerous weapon?
Yes, sir.
Okay, and I was just trying to pull it up on screen share, but I'm having a little technical difficulty, so I'm not gonna try and do it. All right, so you understand the state would have to prove, number one, that you endangered the safety of another human being, here MRH. Number two, that you endangered the safety of another by criminally reckless conduct. And number three, that the circumstances of your conduct showed utter disregard for human life. You understand those are the three elements of the offense?
Yes, sir.
Okay. Your attorney has also filed two documents that appear to have your full signature. One of those documents is called the Plea Questionnaire Waiver of Rights. The other is called the Addendum to Plea Questionnaire Waiver of Rights. I see what appears to be your signature on both those documents. Did you sign both those documents after going through them with your attorney?
Yes, sir.
And you had enough time to go through all the information on the plea questionnaire and the addendum form, enough time to think about the information on those documents, and enough time to ask your attorney any questions if you had any, all before you signed both those documents. Is that true?
Yes, sir.
So is it true then that you understand and agree with all of the information on the plea questionnaire document and the waiver of rights document?
Yes, sir.
Okay. And specifically, Mr. Howard, do you understand each of the constitutional rights that a person waives or gives up as they plead guilty, as those rights are listed on the first page of the plea questionnaire form? Do you understand each of those constitutional rights?
Yes, sir.
So you understand by pleading guilty, you're giving up your constitutional right to have a trial on your case, your right to remain silent, your right to testify and present evidence at a trial, your right to use subpoenas to make witnesses come to court to testify as witnesses, You give up your right to have 12 jurors decide guilty or not guilty by a unanimous vote. You give up your right to confront people who testify at a trial through cross-examination of them. And you give up your right to require the state to prove you guilty beyond a reasonable doubt. You understand you give up each one of those rights by pleading guilty.
Yes, sir.
All right. Did anyone threaten you or pressure you to try to convince you to give up those rights and plead guilty in this case?
No, sir.
All right. So you're making the decision to plead guilty because it's your own free will decision to do so, Mr. Howard?
Yes, sir.
All right. Did anyone make any promises or guarantees to you to try to convince you to plead guilty, aside from the promises made by the state in the plea agreement? Did anyone else make any promises or guarantees to you to try to convince you to plead guilty?
No, sir.
Okay. When we get to the sentencing hearing, and we'll schedule that off for a later date, but when we get there, as we discussed, the state will make a recommendation of 6 years initial confinement, 3 years extended supervision, concurrent to your current revocation sentence that you're serving. Your attorney will be free to give her own recommendation. So Ms. Kremers can say, Judge, here's what I think the appropriate sentence is for this person for this charge. And I listen to what both attorneys recommend. I take their recommendations seriously and consider them seriously, but I'm not required to follow the specific recommendation of either one of the attorneys, because I can always give the sentence that I believe is appropriate, all the way up to the maximum if that's what I think is appropriate in a given case. Do you understand that?
Yes, sir.
And you understand that the maximum penalty that a person can receive for the crime of first-degree reckless injury with use of a dangerous weapon is a fine of up to $100,000 or total imprisonment of up to 30 years or both. You understand that?
Yes, sir.
Okay. All right, Mr. Howard, let me ask you then, what is your plea to count one, which is the charge of first-degree reckless injury with use of a dangerous weapon? Guilty or not guilty?
Guilty.
All right, you're pleading guilty because you agree you're guilty of that crime. Is that true?
Yes, sir.
Okay, thank you very much, Mr. Howard. Ms. Krummer, let me ask you, are you satisfied that Mr. Howard understands the factual elements of this offense in count one and the facts that would support those elements in the case?
Yes.
Are you also satisfied that he understands each of the rights that he's waiving by pleading guilty and the maximum potential penalty that he could face upon conviction?
I am.
And so are you then satisfied that he's making his plea here today freely, voluntarily, intelligently, and knowingly?
Yes.
Very good, thank you. State, do you consent to a jury waiver?
Yes, Judge.
Court approves that waiver. And I forgot to ask you, Mr. Flaherty, you did obtain victim notification regarding the plea and the hearing?
I did, Your Honor. Thank you for asking, because as you know, this plea date and hearing came together kind of at the last second, but we were able to make contact with the victim, MH are his initials. We spoke with him on the phone shortly before this hearing. He agreed with the state's position here concerning the offer. He told us that we told him that he could attend the Zoom hearing if he wanted to, or even watch on YouTube, and he indicated that he had no interest in kind of observing or being a part of the hearing. So I just wanted to put it on the record that we do in fact have victification. So thank you.
Okay, very good, thank you. All right, Mr. Howard, do you have any questions about any of the topics or issues that we covered here in the hearing? Do you have any questions that you want to ask your attorney or the court at this point in time, or do you feel you understand everything in regard to the plea?
No, sir.
No questions?
No question.
Okay, thank you, Mr. Howard. Okay, based on this discussion here, the court is satisfied that Mr. Howard is making his plea freely, voluntarily, intelligently, and knowingly. He understands the factual elements of the offense of first-degree reckless injury, use of a dangerous weapon. He understands the facts and the elements of that case, of that type of charge. Further, he understands each of the rights he's waiving by pleading guilty and the maximum potential penalty that he could face upon conviction. So I accept his plea of guilty in regard to count 1, and based on that plea, I find him guilty of count 1. I judge him convicted of this crime on today's date. Order of judgment of conviction entered into the record. Based on the entry of the plea, the court dismisses and reads in count 2. Okay, we can look for a sentencing hearing date. We can go off the record when we talk about dates. So we'll, it'll be one that we'll have to do an order to produce to have him come up to Milwaukee for that.
Does May 9th in the morning work? At 9?
May 9th. So I'm
And starting week.
danced. Okay. So
You could read my lips, Judge, even without the,
Right, no, I could see your eyebrow raise and I
yeah,
knew it was coming.
Well, I figured because he had a plea hearing already set for 8:30.
Right, but he
that's
complained
why
that-
May 23rd at 9:30.
May 23rd at 9:30. I have an 8:30 in person, so that's perfect. Yep. Well, oh, sorry.
I have
Go
a
ahead.
triple jury trial in Judge Wagner. So as long as Judge Hanrahan is comfortable strong arming Judge Wagner into letting me out of that momentarily, I'm fine.
Judge Wags will never let you.
I
Saying.
don't know. I'm a pretty good sweet talker. What we're talking about 9:30 in the morning on a Monday?
Right.
We
But-
could do the 25th. Can we do the
Just so you know.
25th in the morning?
How about
That
the
sounds
20th?
good.
All right, you want 8:30 in the morning on the 25th?
No,
Yeah, let's
10
do that.
o'clock. 10 o'clock.
Whoa, 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 whoa. Oh, wait, you guys, I'm so sorry. I am out of town 24th on.
Okay.
For in person. I can Zoom cord, but not in person.
Yeah.
Sorry.
How about June 3rd,
June 3rd.
Friday?
State.
That works.
Okay,
Yeah. Dan?
Yes.
Great.
Excellent.
How about
Perfect.
9 a.m.?
9 a.m.
Okay.
All right. Back on the record. So we just had a discussion to look for a date that worked for everyone for the sentencing hearing, and we arrived at Friday, June 3rd at 9 a.m. And so that'll be in room 629 of the courthouse. And Mr. Flaherty, if you can prepare an order to produce to have Mr. Howard come up to Milwaukee for that.
I'll do that
Okay.
right now. Thanks.
Terrific. All right. Anything else for the record from the state today?
No, thank you.
Anything further, Ms. Kremer?
No, thank you, Judge.
Okay, the trial date is vacated. Thank you very much, Mr. Howard. Thank you very much for joining us via Zoom here, and I'll see you up in my court on June 3rd. Okay, thank you very much. That's the end of the hearing.
Have a good day,
Bye.
everyone.
Yep, bye-bye.